have 15 minutes. You may use it as you please.
Thank you, Your Honor. May it please the court, my name is James Armstrong. I represent George Greer. We're here primarily concerning sentencing with operating a motor vehicle under the influence. As both the state's brief and my brief mentioned, the Supreme Court in two cases, Columbus and also South, has referenced the specifications on that, in which they address some of the conflicting language between both the specification, the 1, 2, 3, 4, 5 years, and the felony third degree as changed in 2011, revised in 2011, making it a maximum of 36 months for felonies of the third degree, unless it involves crimes of vehicular homicide, vehicular assault, sexual battery, sexual conduct with a minor, robbery, burglary, etc. The part with regard to that issue that I am doing my best to preserve, since this court is bound by the decisions of the Supreme Court, which kind of ties my hands a little bit based on those two decisions, is the fact that the rule of litany in RC 290104 and the court's decision, the Supreme Court's decision in State v. Stevens, in neither Columbus nor in the South did they reference the fact that ambiguity is supposed to liberally be construed in favor of the accused and not in favor of the state. And
under the facts, what does that mean in this case?
In this case, I believe they liberally construed. You have a statute, Your Honor, that says, in the plain language of a felony third sentencing statute found in 292914, that the maximum penalty for a felony third degree is 36 months. You have a prior, that was in 2011. In 2004, they did the specification statutes. Now, there's no, as best as I can find, there's nothing in the 2011 statute that makes an exception for the specifications. I'm not going to trouble the court with the time with regard to arguing whether I agree or disagree with the Supreme Court. They control my license. I follow their dictates. We always agree with the Supreme Court until we get the Supreme Court to perhaps change their decision. And in that case, the thing that jumped out at me in both those cases is that you do have a statute and you do have case law that says, well, wait a minute, if there's ambiguity, and I believe Chief Justice O'Connor mentions that you have to harmonize the statutes. Well, the other statute that needed to be harmonized was the statute regarding the ambiguity, and that was never referenced in either one. Now, I wouldn't go as far as my friend Mr. Cassay saying that I said it wasn't worth the paper it was written on, as he so articulately put in his brief. But I do think it's a point for our higher courts to take a look in and remember that you may have two statutes that conflict, but you may also have a third statute may answer that question. And whether that was argued, I think it was the State Public Defender's Office that argued those cases, whether the rule of litany was prominently, and I hope I'm pronouncing that correctly, I think I know, was prominently articulated or argued in the Supreme Court. I honestly don't have the answer to that question. All I can go on is what the court wrote in their briefs, and they didn't even reference the statute, nor did they reference their decision in State v. Stevens. In a case that this court certainly has control over, however, is the imposition of the mandatory fine. There are two references in the record to where Mr. Greer had filed an affidavit of indigency, and even if as the state argues, that well, that wasn't right before the sentencing statute. One was done, I believe, in the summer right before sentencing, and the other was a couple of years earlier. The court itself, in its journal entry on two separate occasions, page 2 and page 3, references the indigent nature of Mr. Greer. The last one is when they appointed me to handle the appeal. I argue plain error in that simply because statutorily, according to 292918, it prohibits imposition of fees or fines against an indigent offender.
Okay, but I have a question for you. If it's a mandatory fine, how can the trial court not impose? Is your argument really that they should have waived it, or they should have imposed it and then done something else afterwards?
I would argue that it's a mandatory fine unless the person's indigent.
Is that what the law says?
292918B1 does prohibit fines against indigent offenders, and it specifically says shall not impose.
But under the statute that imposes this mandatory fine, does it say it's a mandatory fine unless the person is indigent?
Correct.
It says that in the statute.
If an offender alleges, this is 292918B1, forgive me for just reading the statute. If an offender alleges in an affidavit filed with the court prior to sentencing, which was done, that the offender is indigent and unable to pay the mandatory fine, and if the court determines the offender is an indigent person and is unable to pay the mandatory fine described in this division, the court shall not impose the mandatory fine upon the offender.
But is that statute a general statute that applies under all circumstances, or does the statute at issue in this case contain language that suggests that it is a mandatory fine that survives indigency?
If that's the case, then we have ambiguity in the sentence, which means the rule of litany, which I raised in my first argument, would apply and go to the benefit of the offender, because he is indigent, and the court itself found in its journal entry that he was indigent. So the fines should not have been imposed based on the indigent nature of the defendant, and I argue that it's plain error. I unfortunately had to argue ineffective assistance of counsel because it was not objected to, and I tried to, at least in a footnote, reference the fact that the attorney who handled the sentencing was, I don't want to say pressed into service like it's the old British Navy days, but essentially was asked to handle the case at the time, and I believe did it as a courtesy to the court and to actually help my client to get this moving faster.
Let me ask a question. I'm looking at the judgment entry on page A2. It says, due to defendant's indigency, the non-mandatory fine is suspended. So the court did address the non-mandatory fine and suspended. But it did not address the mandatory fine and suspended. Is that what you're saying?
Correct.
And you're saying that the statute makes no distinction?
My reading of the statute does not, Your Honor, and the reading of the ambiguity should favor the accused, not the state. And in this case, it clearly says shall not impose. And there's and as if you look at the F3 statute as amended, 292914, when it says you can't sentence anybody to more than 36 months, it then goes on to say, except in these conditions.
Does the same thing apply to court costs, or is it just the mandatory fine? Because it seems to me that it says that the judgment is granted against the defendant in favor of the county for the mandatory fine and the court costs, but not the non-mandatory fine. So the costs, what about our costs? The costs should be waived as well. Is that what you're arguing?
I would argue that, yes, absolutely. If the person's indigent, the person's indigent. And if the court's found that he's indigent, which it had, then opposing a fine on somebody who the court is aware of is unable to pay, and the statute says should not be opposed, I would interpret it both ways. But I asked the court, certainly on the issue of the fines, to reverse and remand this back to the trial court so they have the opportunity to comply with the statute, its clear language of the statute. With regard to the argument that I make initially with regard to the sentencing, I asked the court to follow the law, both statutory and case law in that matter.
If you're done, you still have 5 minutes.
Judge Whitmore, I see you doing what you can to be through here. This is pretty much a straightforward, and I will be here Thursday arguing a case which I guarantee I'll use all 15 minutes for.
If I'm still on the bench Thursday, I'll hold you to it.
All right. Thank you very much, Your Honor.
Thank you. Have a good day.